Okay. Hello, everyone. Welcome to our council meeting for July 16th. I'll call the meeting to order. It's the regular meeting for the town of Atherton. May I have the Pledge of Allegiance? Everyone stand.
I pledge allegiance
to the flag of the United States of America, to the republic
for which it stands, one nation,
under God, visible, with liberty and justice for all. Thank you very much. May I have the roll call, please, Anthony?
Yes, Councilmember DeGolia,
Yes.
Councilmember Whitmer.
Yes.
Vice Mayor Holland.
Here.
Mayor Lewis.
Here.
And I'll
Thank you.
note that Councilmember Hawkins has had a pre-planned absence.
Yes, she's excused absence. Okay, our next item on the agenda is presentations, and I have none at this point, at this part of the agenda. And then the next item is public comments. Public comments, just to let you know, is reserved at this time for a portion of the meeting on items that are not on the agenda. There will be other opportunities to speak on items that are on the agenda later. But it has to be within the jurisdiction of the town of Atherton and pertinent to our city council. So is there anyone who'd like to make a public comment at this time on items that are not on the agenda? And you will have 1 minute. And no one online? Okay, we'll move on. The next item is disclosure of ex parte communications. City council members should disclose any communications that they have had on items that are on the agenda at this time. Oh, Councilmember Whitmer.
Yeah, when the appellant, Michael Templeton, first identified he was appealing this, and before any other letters came out, I had contacted him and I offered to go over to his property, go over the situation. So he and I did go over and meet that afternoon, and I saw his property. I saw the property next door, what they were doing with the building there. So, okay.
Okay.
Yes, I've had a number of conversations with different residents about the item that is the parking permit on Ashfield and Maple. And I've had a number of email exchanges with people about the pickleball recommendation from Park and Rec, which is item number.
Okay.
I've had email correspondence about pickleball.
So I've had, I was contacted by the owner of 94 Palmer, and he asked if I would come take a look at the property, which I did. And we walked the property down the flag lot and looked around and saw the situation. That's what I did. So, okay. Next item is our departmental written reports. I understand that the departmental written reports are not included in the packet this time.
They're not included in the packet, but there's a link to the archive online. And just today, we got that compiled, and it's up on the town's website. It'll be part of the council notes packet on Friday.
It contains a lot of wonderful information about the town and what staff is doing, and in all areas. So if you have a few minutes to go online and read that, you'll be surprised and delighted at how much progress is being made all around our town. We did not have a closed session, and so we'll go on to our consent agenda. Our consent agenda is occupies items number 1 through 7, and it is typically moved and seconded and approved in one motion, unless someone in the public would like to pull an item 1 through 7 for discussion or questions. You have that opportunity now. One online. How about any member of the council wanting to pull or discuss any questions on items 1 through 7? Not, I will call for a motion.
So move. Second.
Okay, we have a motion and a second to approve the consent agenda, items number 1 through 7. All in favor? Aye. Any opposed? Any abstentions? The motion passes in one series. We'll go on now to,
My phone.
Siri thought I was talking to her, but I have her on mute, I thought. I need to put her away. So the next item on the agenda is item number 8. I'm going to have open the public hearing, and I'm going to beg your pardon while I read some information that our city attorney has asked that I read. It's not often we hold public hearings like this, so just want to refresh everyone's memory and kind of lay out the procedures that are going to follow. This is a public hearing regarding the appeal of the Planning Commission's decision to approve a request for variance and TPZ exceptions at 94 Palmer Lane. The council may reverse, modify, or affirm the decision of the Planning Commission in whole or in part. Pursuant to Municipal Code Section 17.06.100, I will now summarize how this appeal will transpire. First, I will ask members of the council to publicly announce any testimony or evidence received outside of the hearing process, which we call ex parte, which we've already done. So I'm going to go forward on that. Or do you have any conflicts of interest concerning this matter, and any member with such a conflict should disqualify him or herself at this time? Have any conflicts about this matter? Okay. So I'm going to ask the staff to make its presentation on the background of the item, and after staff makes its presentation and the council has had an opportunity to ask questions of staff, I'll ask the appellant and any interested members of the public to speak. The appellant will be given 10 minutes to make their presentation. Following the presentations by the appellant, members of the public will be given the opportunity to present testimony, and public comment will be limited to 3 minutes each. The applicant will have an opportunity also to respond and have 10 minutes for a response. The appellant will have opportunity to respond to the testimony or the evidence following public testimony, but they may not introduce new testimony or new evidence or restate their direct testimony from the outset of the hearing. And that will, we will give the appellant 5 minutes for rebuttal. Following that, we'll close or continue the public hearing at the council's option, and staff may be asked to address issues that have been raised by the appellant or in the public testimony. Then council will deliberate on the matters and adopt findings if appropriate. The final decision will be deferred for preparation of draft findings consistent with the preliminary decision that is reached this evening. So going on, I'd like staff to provide us with the presentation at this time. Brittany?
Thank you, Mayor Lewis. Brittany Bendix, Town Planner, here to speak on the appeal request at 94 Palmer Lane. Our recommendation tonight, just to frame this for you, is that City Council deny the appeal and uphold the decision of the Planning Commission to approve requests for a front and rear yard setback variance, as well as tree protection zone exceptions that would enable construction of a new single-family home with detached garage and attached ADU at 94 Palmer. This next slide is a general background of the context of the site. It is a 0.32 acre flag lot within an R1A zoning district. This immediately jumps out because we're used to seeing 1 acre properties in the R1A zoning district. The site is located at the town's border. Everything highlighted in yellow indicates the R1A zoning and the town's jurisdiction. Beyond that is the community of North Fair Oaks, which is in unincorporated San Mateo County. This lot was established in 2023 through an urban lot split. We also refer to that as SB 9, but we see subsequent bills coming after SB 9. So I'm going to transition to talking about it more as urban lot splits in the future. Previously, that lot included both 98 and 94 Palmer, was a total of 0.55 acres. Still, again, under that R1A threshold that we're used to seeing of 1 acre. The new lots were established in 2022, or sorry, the 0.055 acre lot was annexed into the city and established as, well, sorry, was not annexed. It was created as part of a subdivision in 1922. So there's a typo on the slide there. It was part of the Barney Park subdivision. This slide is generally captured from what I shared at the Planning Commission. It notes that neighboring properties range in lot size from 0.12 to 0.77 acres. That's generally describing all of the lots you see in the image there. What I've supplemented this slide with, since it was published in your staff report, are all of the lots that are within the town's jurisdiction that are smaller than the current subject property at 0.32 acres. So anytime you see a star there, it's less than 0.32 acres.
Ask a question.
You're going to have an opportunity.
Right on this slide.
Oh, okay. Here.
So just the bullet point that says prior lot was 0.55 acres established in 2022?
That should say 1922.
Oh, that meant 1922.
Yeah,
Okay,
it's a
that
typo.
makes sense. Thank you.
Next slide.
Wait, I'm sorry.
There's no, this is not a public discourse portion, so you'll have a chance to make public.
Yeah, is there a correction? That's all I was going to say, the 0.12.
You'll have a chance to make comments at one point.
We will not interrupt our presenter right now. Yeah.
So the general project description is accompanied here by the site plan that also includes the first level of the development. The project includes a new 2,961 square foot residence, detached garage, an 800 square foot ADU, and the siding of the layout of the property, they've located the ADU along the North Fair Oaks shared property line, and they've provided the driveway along the Atherton neighbors property line. This will result, as you'll see, in the project's ability to meet the side setback requirements for the R1A zoning standards along both property lines. Next slide. When the SB 9 lot split was approved, it resulted in a buildable area that's shown on the slide or on the image in the right here of approximately 185 square feet if the applicant were to apply the R1A setbacks. Alternatively, they could choose to use the SB 9 or urban lot split setback standards of 4 feet. In this case, the applicant is choosing to go with the R1A standards, but then that restricts the actual development area. So they are seeking variances for just the front and rear setback requirements in R1A. The typical R1A standard front and rear setback is 60 feet. What the applicant has done here is they've modeled what they're proposed based on a provision, an existing provision in the R1A zoning that would apply to any lots that predate that requirement, where you're allowed to reduce it by approximately 30%. This lot was established in 2023 as part of the urban lot split, so it can't meet that specific provision of the R1A zoning that it reduces the front setbacks. But if it did, it would match the 37 feet, 4.75 inches. So that's what they've used to kind of model the placement of the structure. The height is also compliant. I mentioned previously, the side setbacks are compliant, and the FAR that is applicable to this lot is compliant as well. Next slide, please. The TPZ exceptions address 6 coast live oaks that are along the shared property line with the Atherton neighbor. The trees range in from 16 inches in diameter at breast height to 32 inches. They're generally in good health, but they are shared trees or they're on the neighbor's property. The resulting tree protection zone, which should be 8x, is reduced down to 3.7 or 7x. Just as a reminder, the X denotes the 3.7 times the diameter at breast height of that specific heritage tree. And this was supported by the town arborist with accompanying conditions of approval that the Planning Commission included in their adoption. Next slide, please. The issues, this is very high level of the issues raised by the appellant. They include privacy intrusion, specifically at the second floor of the proposed development, excessive visual impact of the proposal, inadequate and imbalanced screening along the property lines relative to landscaping, the noise and potential door noise from the orientation of the entrance of the unit, anticipation of construction disturbances, the notion that this is a self-created hardship that is financially motivated, that the project is incompatible with Atherton's character, and that there is an environmental and aesthetic degradation based on the proposed development. It represents excessive lot coverage, and there was a lack of proper notice and neighbor outreach. I can confirm, as I did in the staff report, that the neighbor was sent public notice as required by law for the hearing that happened at the Planning Commission. Next slide. This slide represents the applicant's response that was provided in the staff report and attachments. They are requesting that the council uphold the Planning Commission approval. They've noted that there were some unique design constraints due to the lot size and that they did attempt to place the building in a manner that was most sensitive to the Atherton neighbor. That has been done through a long-term collaborative planning effort with the planning department through the even review of the urban lot split application. There is compatibility with the neighborhood and thought towards the tree protection measures that they've put in place and worked with the town arborist on. As I mentioned previously, the side setbacks are compliant and the siting of the ADU is located on the opposite side of the appellant's property. Additionally, they've offered to work in some privacy concessions in response to the appellant. And this graphic at the top here notes that they're willing to put some screening in at the second level windows of the new proposed residence. And just to give you the sense of vegetation that's currently there along the property line, the applicant also included a photo of the property line from that vantage point that they took using a drone. The red line indicates the fence height as well as the fence location from that view. Next slide, please.
That's new information.
Okay.
So our recommendation, once more, is that the City Council deny the appeal and uphold the Planning Commission's approval of the front and rear setback variances, and as well as the approval of the tree protection zone exceptions.
Thank you, Britt.
That concludes my presentation. You can
Thank you very
continue.
much. I'm going to bring it back to council for any questions for staff at this time. Does any member of the council have any questions for Brittany?
I have a question. When I reviewed the file, the staff report, I was surprised that there was no appeal or that the appellant didn't comment at the Planning Commission. And I don't know if this is for you or for Mona, but is there a requirement that if somebody wants to appeal a decision that they have to, make
Exhaust
that
their
kind of
administrative
finding?
remedies.
I'll let Mona answer that.
Yes, the short answer is that an appellant typically has to exhaust their administrative remedies, meaning that they should present their concerns before the planning commission. The public policy surrounding that is so that the decision maker has all the available opportunities to listen to that and potentially adjust their decision. In this case, the appellant, one of their contentions is failure on the part of the town to provide notice. And so they are alleging that there is a procedural defect. We disagree with that, and the staff report demonstrates with attachments that prove that beyond the 10-day public hearing notice that is required in the government code, that staff provided 12 days public hearing notice. So on that grounds alone, the appeal may be dismissed, but even on the merits, staff's position, which I support from the legal perspective, is that the findings do support the variance request and the appeal may be denied.
Questions for Brittany? Councilmember Widmer,
Mona.
yes. Oh, for Mona, yes, okay.
Yeah, in the report, it indicates that both the appellant as well as one of the other neighbors did not get notification. So there are two people that say that. So I understand that we have a notary document that says that it was placed in the mail,
Right,
but we don't know whether or not the mail actually got delivered.
right.
Because-
So
Because there is a lot of mail that's not being delivered these days, I can personally attest to.
I appreciate that. So again, just strictly from a legal perspective, the government code states that there is the presumption that when a government agency has mailed something, that it has been actually mailed and delivered. Now, there's a reason why, in addition to mailed notice, from a belt and suspenders perspective, there's additional notice, right? There's the agenda packet that goes out, it's posted on the website, and then there was that public hearing notice posted throughout the town. But again, out of an abundance of caution, this appeal was presented to the council to make those determinations.
Okay, thanks.
No questions?
I have another question.
Oh, certainly, of course.
So
who?
I understand, I thought that Sally was going to be here, but no issue there. There are a lot of trees that are here, and obviously screening is one of the conversations that's been brought up. But the trees are high, and so the branches are higher, and so I didn't see whether or not there was any lower level screening being required, which is going to be at the ground level up to about, let's say, 12 feet. Was any of that discussed?
Debbie to Brittany.
There's no identified screening at this point in the process. That would actually come at the building permit submittal. And then Sally would go out to the site when she's reviewing the landscape permit, and there is actual framing up that enables or facilitates the proper location of plantings to ensure that screening is met per the applicable code standard. And that actually was discussed at the Planning Commission without it having been raised by any neighbor or public comment.
And what was the response of the planning commission?
That is the standard process.
All right.
So I have a question for you, Brittany.
Sure.
It's actually a clarification, and I just want to make sure I heard you correctly, that even with the urban lot split, or without the urban lot split, no, with the urban lot split, that this property could be developed much more closer to the setbacks instead of going under the R1A setback rules and asking for a variance. Could you clarify that for me?
Sure. So as this property was created through an urban lot split, the applicant has the right to pursue two 800 square foot units at 4 feet from the side setback without a height limitation except what's in the zoning code.
Okay. What's the square footage of the structure that we're talking about now, not without the ADU?
Let me bring that up. It's 2,961.
961 square feet.
Okay. And that's going, so that without the, he would only be allowed to do 2 800 units under that other scenario, up to the 4-foot setback of the
Correct.
property lines. But with this other, you can build larger, but you have more setbacks.
Correct. You're adhering to the town's underlying zoning district setbacks,
Okay.
which
Right.
they are meeting from the side setback standard, but they needed an exception for front and rear.
But it's still a whole lot further away than just a 400-foot setback.
The 800 square foot,
Yeah.
yes.
Yeah. You follow up?
One other question. So I'm always sensitive to conversation between neighbors about screening, because especially when a new building is built, screening is really important, and we've emphasized that in all of our policies related to building where we could. And I understand that there's some requirements from the state that make those not forcible. But in general, when there's a complaint about inadequate screening, my experience has been that the neighbors often kind of work it out, and there's adjustments notwithstanding what the requirements are that satisfy the neighbors. And I understand in this case that there wasn't an objection for this whole variance request when it came before the Planning Commission. But my question is, has there been any adjustment from the property owner in response to the appellant objection that there was imbalanced or inadequate screening?
Sure. So I was going to let both the appellant and the project applicant speak more to this. I believe the appellant found out about the hearing just a few days immediately after it took place. And so I engaged them and we discussed the situation. And then myself, the appellant, and the property owner met to discuss potential solutions. And a variety of things were suggested, such as landscaping treatment, working collaboratively at this point to identify the location of trees, an offer of a certain quantity of trees. Ultimately, that was rejected in favor of filing the appeal.
Okay. All right. Okay.
But
So,
just
well,
the
follow up from Rick DeGoya and
follow-up to the
then,
question is, was there any adjustment that the property owner made? And maybe we'll hear that tonight.
the applicant,
No, not the applicant, the property owner.
the appellant.
Both of them are
The
supposed to
is
speak.
it an applicant and an appellant?
Yes.
The applicant. And was there any adjustment that the applicant made in the screening, notwithstanding that the screening discussion didn't result in a satisfactory conclusion?
No.
Okay, thank you.
Councilmember Widmer.
Thank you. This is my last question. In the staff report, it indicated that I guess there was an opportunity for both the developer as well as the appellant to get together and discuss things such as one of the things that's been mentioned to me is moving of the door, not having the front door to the second building being facing his property, which is something, of course, when we said we don't want to see happen. Is there any discussion on that? And was there any movement? Because I see the plans still say the same.
You're
Door's
talking to
still-
Brittany. You're not, no, we're not engaging
Okay.
the appellant or the
Okay,
applicant
okay,
at this
Brittany.
time.
So, typically when the property owner sits down with a concerned neighbor prior to an appeal being filed, the understanding is if I make these adjustments, we will not go through the appeal process. You will not delay my project further and I will be able to move forward. When that does not happen and the appeal is filed, the property owner then has the option to not change the plans at all. Here, what they're offering, what they've included in the staff report is a willingness to obscure the windows. But at this time, they're not looking to make any immediate design modifications outside of collaborative effort that wasn't successful initially.
Thank you. Okay, I'm going to close this discussion at this point, and I'm going to invite the appellant to come forward to give his presentation. That would be you.
I could do it 2 ways.
No, I think you come up to the podium, state your name into the microphone so we can hear it in the recording.
Okay,
And then you have 10 minutes to talk.
Okay, I don't
Okay.
have, I don't get a slide presentation. Okay, all right, that's
That's
fine.
okay. Just
Yeah.
talk for 10 minutes, and after 10 minutes, we're going to up to, Councilmember DeGoya says up to 10 minutes. If it's shorter,
Okay, up
that's
to 10 minutes.
fine.
Okay, if you turn to the page in your brochure, it says notice here. I gave you after the grievance letter, it says notice, the issue of
Is
notice.
this, are we
No,
looking at
yeah,
this?
After the third or fourth page there, you'll see a thing that says notice, okay? All right, so it says, I was probably not given proper notice for the meeting on May 28th, okay? So as I found out also from Tom Ford, that the notices were given to a vendor on the 16th. That gives you 12 days, which we said here. That gives it 12 days to receive that item, okay? So, but that item has to go to the vendor. It has to go to the post office. The post office has to stamp it, and then it sits in the mail system. And we won't receive it till the 19th, probably the 19th. So we only got that letter on the 19th, okay? Most likely on the 19th. And the meeting was on the 28th, okay? That's only 9 days. In addition, there was Memorial Holiday in there. Okay, so if you look at here, down below, I have the quotation for the Bagley Act. It says, notice shall be given and also made available on the internet at least 10 days in advance of the meeting. Okay, that's the Bagley Act. It says notice. It doesn't say postmarked, posted, anything else. The purpose of the Bagley Act is to make sure that the people involved get notice of the meeting. If it's expected to sit in the mail for 3 days, we are not getting our 10-day notice. It doesn't say about 10 days, prior to 10 days, et cetera. So I just want to say that I did an experiment where I actually mailed 4 letters on Friday, last Friday, and on June 11th at 10:45, the Bohannon pickup in the Menlo Park at 11:30, and also at the Redwood City Post Office at 11:30, and also at the Bohannon at 12. And I received all those letters in the Monday mail, okay? So I only got 9 days of notice, okay? Just to correct the record. And I don't believe, if you look at the Bagley Act, it agrees with you. Most attorneys will say, oh, it's the postmark date. I don't believe that's true. Okay, and I think if you consider that also, was there a valid meeting? Did you have a valid, all the other people didn't show up. You also elected the planning commissioner at that meeting. And was that a valid meeting election for the planning commissioner? Did he make a valid ruling and on this issue at all? Okay, so I think that's the strict law. Okay, the next is I want to talk about, if you go flip over the next 2 pages. I'm sorry. I want to talk about variances, okay? One about hardship. There are basically three things typically for variances. You have to show hardship. Okay, the applicant has to show a hardship, but typically it can't be a self-inflicted hardship. So for example, if the applicant buys a parcel and then splits the parcel, when he goes to develop the split parcel, he should not be able to claim the parcel is too small, because by splitting the parcel, he himself caused it to be too small. Okay, it looks to me, like all of the other SB 9 lot splits that are taking place in Atherton, those 8, all of those, I looked at some of them, are on 1 or 2 acre parcels. And the people who did that recognized that they would have to have meet the zoning requirements, and they decided that they didn't want to have to go through the variance process. And so they bought parcels that were big enough so they didn't need a variance. Okay, so the other issue is, I believe the facts are wrong on the, if you have the facts wrong on your application for where the setback boundaries are, you shouldn't be able to get an appeal. And if you look at the document there's a setback requirement between unincorporated Menlo Park and Atherton. Okay, the setback requirement in the document is listed as 25 feet. Okay, in unincorporated Menlo Park, the setback requirement is 10 feet. If you are adjoining that boundary, you are only required to have a 10-foot setback. Okay, if you're in Atherton, it's not 25 feet. So the document that this planning document that this is based on, the appeal is based on, is actually incorrect. The facts are wrong. And I think it makes a big difference on how the hardship works out, because if they can move the house another 15 feet to one side of the property, it allows a lot more space to free up on the other side. Okay, let me talk about some other things. Okay, so I want to talk about, let's see. Yeah, okay, I think I covered that. The other thing is there a good faith effort, when you're seeking a hardship, is there a good faith effort to come up with another solution? I didn't see any effort from anybody to come up with a good faith solution. Okay, so the next page I have extents or area variances. As the variance suggests, it's not typically supposed to be a large change in the base number, like 10 or 15% is all you can expect. In this case, the applicants have been granted basically a 37.7 or about a 40% variance. Okay, that's a huge variance. And this is considered unusually large. And the other issues that I worry about is that the front of their house actually faces me. Okay, their garage doors there, their front doors there. They have the driveway there. If you're strictly speaking about the usage, it should be like 60 feet away from me, okay? Otherwise, but it's only 25 feet. And so I don't think that from a usage point of view, it's a huge impact on me, okay? And that's why I suggested a number of ways to mitigate that by changing the position of the door. I had a discussion with the applicant for the variance, and yeah, he was willing to do that. But in the end, I didn't think it was enough to have something there that is 25 feet away, invading my privacy from that area, and all the other issues involved in it too, including the tree protections, et cetera. So let's talk about justice. Okay, typically when you have variances, the reason variances are granted, it's important that one of the third issues is justice be done. You have to not burden somebody else with the problems that you have. So as I said here, you cannot expect someone else to bear the burden of the variance. There needs to be substantial justice to me as a party. I don't see any effort made to unburden me of some of the issues here. It says, currently I am being burdened by some of the proposed variances. There's a noise and disturbance that Brittany alluded to. There's a direct overview and invasion of my property. I am providing material, most of the screening, both upper and lower. The tree protection variance for the driveway is absolving them. It's actually absolving them of any responsibility to put any plantings in that area. They say, oh, well, wait a second, it might damage your tree roots. And the only justice I got from this is, you know, maybe we'll give you a little money to put some plants in there. And it's, you know, it's going to be up to me. And I just think that that's wrong. Okay. So also, I would say there is no incentive for the town planner to make sure justice is done. And I think essentially the town planner's proposal to approve the setback variance provides no justice for me at all. And my neighbor at Holbrook Lane behind me has some concerns too. In my grievance letter, I suggested that mitigation, moving the main entrance away from me, side facing the property, and getting rid of the small garage along the driveway would be useful things. You know, changing the entrance. But that was in my grievance letter after I talked to this individual, and we had some discussion. But that was the grievance letter I had to write over the weekend, and that's something I came up with. And then Brittany said, "Oh well, okay. Will you take that?" And I'm thinking we can do better than that. Okay, if there are some issues with the facts on the plan, for example, if the setback to the adjacent R1B zoning district, unincorporated Menlo Park, should have been 10 feet instead of 25, and the property can move back. We need to think about what's going on there. And so, the last thing I want to say is, despite the town planning's extensive interaction with the variance applicant, I was never once informed of the ongoing process, despite one of the tree protection zone exception slides saying in there, it said in there, outreach to neighbor. Nobody ever contacted me. Despite the planning department was also saying, we are doing this for you. I was never asked what my opinion was or what I wanted, okay? So my concern is that the behavior here was extremely prejudicial to me. Nobody bothered to talk to me. People just wanted to ignore me, et cetera. Okay, so
Thank you,
that's
sir.
all I have for now.
Thank you very much. Thank you very much. Now, I'm going to bring it back to council and ask any council member if
Okay.
they have any
Okay,
questions
sorry.
for you. So
Yeah.
just remain right there for just a
Sure,
minute.
okay,
Now
yeah.
we've heard your argument, your presentation, and is there any questions from council members to this appellant? Councilmember Widmer.
Yeah, so it's not clear to me, you had a meeting with the architect and you discussed a number of these things, and your recollection, they were ignored, or what got accepted?
Okay, so I heard about it. I called Brittany. She arranged for me to meet with the applicant, and we talked a little bit about what's going on. I told him, if I can't hear you and I can't see you, you're not there, okay? And I explained some of the issues about the noise, because I lived next to someone for a long time who had it used to be in Atherton that you couldn't have a door opening to the side. It had to be front, rear, or internal. And so this person had gotten rid of their driveway, and so they put their so they had their car parked by the side of their house, and they needed some way to get to that car easily and take their garbage out. And so they put an illegal door there, and then later that turned into their formal door, and they would always slam that door. And
Thank you. Okay, we got that.
Okay, I got
but well, there's other
Stacy,
issues.
Well, just, Stacy has Vice Mayor would like to ask a question.
Well,
Yeah,
I
I was
didn't
gonna
answer
ask-
all the issues there.
Just 1 second.
So we had some discussion about that, and then we had let's see, we talked about the screening upstairs. We talked about moving the door, and I just and then we had a discussion about the color. If I can't see you. And I said, maybe you could paint it a green color, kind of a darker green color. And he, and also you could, so he basically refused to even consider changing. I want to paint it a tan. And also I talked about trying to take the traffic away from the front door. And he said, oh yeah, maybe we can put some bushes in there. And, you know, my conclusion after all that is he really wasn't serious about doing anything. You know, we can put some bushes and direct traffic around. So he wasn't really serious about mitigating some of the issues I had. And so therefore, I went and I wrote the appeal letter. And during that weekend, I thought of some of the other issues that came up. In fact, I proposed, you know, one of the, I said, what if, you know, scenario, you know, I'm just brainstorming and thinking about this. And I'm thinking, you know, what can we do to solve this problem? And what is the cost benefit? For example, you know, the reason they have that tree protection zone is just to access a 200 square foot garage down at the end of the road. Why is that there? Is that really a, you know, it causes a lot of pain for me. It impacts the trees in that area. You know, if you didn't have that garage there, or you put that garage somewhere else, you wouldn't need all that stuff there. And I thought, you know, maybe we could put, you know, that was my proposal in my grievance letter. Okay. To that person, and I think I came up with some other ones. But I'm thinking, you know, one of my concerns is that the applicant, you know, they worked on the first house. Okay, that was a 94 Palmer Lane. They did a remodel of it. Okay, they did a remodel of not.
Okay, excuse me, I'm going to interrupt you because I think you'll take all night because there is so much inside you that you really want to get out.
There's a
So
lot here.
We
Yeah.
do have other council members that have questions, and so
Okay,
I'll
okay.
turn to
Hear from the other
our vice mayor.
Okay.
Yeah, we're just for questions, and we're going to limit it. Actually, the responses should be limited just about a minute in response, okay?
Mike, I was just gonna read Bill's question of trying to understand why you walked away from the meeting that was facilitated by the planning department. So you've answered it now, so
Oh, okay.
I'm good.
Councilmember DeGoya.
Yeah, I had a question. In your letter, you commented that you talked to Jerry Martin,
Yes, I did.
and Jerry Martin is part of planning, is that right?
Yeah, he's on the planning thing. I had went there the April 22nd. This is part of, you know, I had gone to the planning department to find out if something was going on there, and nobody, you know, he didn't say anything about it. And largely related to, you know, there's a requirement that someone live, you know, the document that said people have to sign that they have to live there 3 years. And it actually says they have to live there 3 years on the property or then some government code. And and it turns out that that government code, which I didn't understand, was what the important part was. Okay. But nobody told, during my course there, nobody said, hey, listen, they're applying for a variance on 94 Palmer Lane. So I didn't know, nobody even told me in planning department.
So when you talked to Jerry Martin
Yes.
in April,
In April 22nd.
which was obviously before the planning commission meeting.
That's right, yeah.
There wasn't yet an application for a variance, I take it?
Maybe there was, and nobody told me that.
Can I speak to this? Brittany Bendix,
Brittany.
Town Planner. There had been a variance application filed. It was under review. I think Jerry Martin is counter staff. He answers generic questions at the planning information desk. I think he was responding to questions relative to the SB 9 split, and he was not aware either that there was a variance, and he didn't look into it because he was focused on this nature of the occupancy question.
So I have a question.
Yes, please.
I actually went to the site and walked through the back yard area, saw the pool that's going to go away, which I'm sure you're going to be very happy about because
No,
it's
I'm not.
Anyway, so and it just seemed to me that there was so much landscape screening along the perimeter of your property and the applicant's property that you just, I mean, I couldn't see your house from where I was standing. And he showed me on his phone kind of the layout and the plan. And it is like in the way back of your property, it doesn't look into your house at all. In my physically being there, but you know, I can understand you feeling potentially invaded and your privacy to be invaded. And I feel your passion about that. But I've just, can you explain what really is facing the applicant's new structure in the back from your backyard?
Yeah, it's just the privacy of my backyard. I go out and
Okay.
garden and do things like
Uh-huh.
that, and I'll hear all the noise and the traffic and egress.
Okay,
You know,
all
if you
right.
spend some time back there.
Yeah, but it's not looking into windows of your house.
It's not looking into,
Okay,
into the
thank you.
windows of my
Okay.
house
That's all I
at this
had.
time, yeah.
Okay, thank you so much. I'm going to ask you to take a seat now, and I'm going to welcome the applicant for his 10 minutes of presentation. Please state your name.
My name is Andre. I'm the property owner and the applicant. I am with the architect and the attorney. The architect will go through also the technicality of the plans. I would like to do just a brief introduction. I would have something to say, but I care about the neighbor. I really do care. All the opportunity I had to try to come up with something, I tried to do it. When we had a meeting at the planning department, at the planning, I tried to understand and be empathic of what would make sense for him, right? And I was open to that. I was open to change the door direction, for example. I was open to put like obscure glass on the second story. And then, so I think that's the important thing to say. And then I'm still open, you know, to organize it in a way that respect him. That's our approach. I think during the process, Brittany witnessed that I always try to understand, do the best I can for him to be happy, right? But I have rights as well. And then about the door, for example, I said, hey, because I tried to connect, we met on Friday, I tried to contact him on Monday and was not possible. And then, and he already, he already started his process. So just organize that. So before that, after that, I would like to fair review a small letter that I did to express how do I feel about it somehow, right? So sorry about my English, I'm not a native speaking, but I'll try my best. So good evening, council members. Before our architect walks you through the technical merits of this project, which we believe stand on solid ground and have already been unanimously approved by the Planning Commission, I'd like to take a moment to speak from a broader perspective. Because beyond architecture and code compliance, there is about the kind of choices we make day by day to build a society that is more just, more accessible, and more inclusive, without losing what makes Atherton such a unique and special place to live. We fully acknowledge and respect the concerns raised by the neighbor. Privacy matters, neighborhood character matters. These are not minor issues for us. And we treat them with the seriousness they deserve. Over the course of more than a year, we worked closely with the city planning team, revising the plans, shifting windows, adjusting massing, and even trying to unsuccessfully to reach a direct compromise with the neighbor. Still, we believe this project deserves approval, not only because it complies with the law and is compatible with the smaller surrounding lots of this neighborhood, but because it aligns with a large civic responsibility that we all share. As part of the housing element, Atherton has committed to enable 348 new houses by 2031. And that commitment won't be met through broad vision statements. It will be achieved through specific decisions like this one, made on case-by-case basis with responsibility and common sense. This proposal is not just for a single-family home. It also includes an accessory dwelling unit, a type of housing Atherton has specifically prioritized on this housing element, with a target of 26 ADUs per year. These units offer flexibility, affordability, and contribute meaningfully towards the city's requirements housing production goals. The Planning Commission voted unanimously, 5-0, to support this project. That kind of consensus reflects a design that is balanced, technically sound, and respectful of the context. We are proud to have preserved every native tree on site. We listened, we adapted, we made trade-offs. And that is what true community mind development requires, not perfection, but good faith, reasonableness, and civic purpose. Every public decision involves some level of discomfort or compromise. But that's how communities grow. Though, truthful action, not inaction. This is how we align responsible housing growth with the Atherton long-term vision. I respectfully ask you to approve this project, not because it's easy, but because it's the right thing to do. Thank you very much. So Kelly is the
And
architect.
she's going to finish your 10 minutes?
Yes.
Yes, thank you. Please state your name.
Yes, hi, my name is Kelly Johnson, and I'm the architect of record
Okay.
for the front and rear setback variance and the tree protection zone exception. We began working with the planning department in April of 2024, and throughout this 15-month process, we listened carefully. We worked diligently, and we spent many, many hours and resources designing a solution for this property that would be compatible with the neighborhood and respect the privacy of the immediate neighbors. Additionally, we worked with the town arborist and the fire department to provide the maximum protection for the heritage trees and to still allow the property to be accessed and protected in a disaster. The solution that we presented to the Planning Commission is respectful to the neighbors in scale and in the distance from the property lines. It is a good fit for the community and is in line with the development standards along Palmer Lane. The project complies with all R1A development standards, with the exception of the front and rear yard setbacks. It's important to note that although the appellant complains of the 26-foot setback facing his property, we are not asking for a reduced side setback, and this 26-foot setback is allowed without a variance. And as a good faith gesture, we have proposed to further address the neighbors' concerns by offering to obscure the lower portions of the second floor windows facing Mr. Templeton. Yes, there are other options available to us on this site through an SB9 lot split. But to be honest, the neighbors will find two 800 square foot ADUs and their allowable detached garages to be much more intrusive due to the fact that we can locate the ADU structures 4 feet from the property lines, and we do not have to take into account the TPZs of the heritage trees. We can also stack the two 800 square foot ADUs on top of each other, just 4 foot from the property line. But this does not seem like a respectful solution to our neighbors or to the community. This project, as currently designed, is a common sense solution. And the Planning Commission supported us 5-0. We ask that you uphold the Planning Commission's decision. I would also like to introduce to you our project's land use attorney, Camus Steinmetz of Jorgensen, Siegel, McClure, and Fliegel, located in Menlo Park. We would be more than happy to answer any questions you might have tonight as you continue this discussion of this project. Thank you.
How much more time do they have? You have 2 minutes. Come forward to state your name, please.
Good evening, Mayor and members of the council. I wanted to just briefly address the letter that was delivered to
Please
you a
state your
couple of
name.
hours ago. Camus Steinmetz.
Okay, thank
of
you.
Jorgensen, Siegel,
Thank
McClure,
you.
and Fliegel. So the letter is arguing that the legal findings for the variance cannot be made, and I respectfully disagree. State law and the town's variance ordinance allows for variances or deviations from otherwise required zoning standards in cases where there are special circumstances applicable to the property, where strict application of these standards would deprive the property of privileges enjoyed by other property in the vicinity and under the same land use classification. Here, given the uniquely small size of the property, applying the front and rear setback requirements would allow only a 135 square foot building footprint, which is barely big enough for a room, let alone a single family home. So adhering to these setbacks would deprive the property of the privilege of a single family home enjoyed by other R1A zone properties in the vicinity. Ms. Aitchison does not dispute this, but she argues that this special circumstance was created by my client by the SB9 lot split and therefore is a self-induced hardship. She cites no case law authority for this proposition, but from my research, it appears that the one single case supporting this was a 1961 code enforcement case, ironically in the town of Atherton, where the owner sought a variance to construct a tennis court in their front yard after selling off a portion of the property where they could have constructed a tennis court in compliance with code. The town denied the variance. The owner went ahead and built the tennis court anyway, and the court upheld the town's denial of the variance. So in contrast to that case, here there is no code enforcement situation. And unlike in that case where the court was considering denial of a variance, this appeal concerns the granting of a variance. And furthermore, state law mandates approval of SB 9 lot splits as a matter of right. Additionally, in determining whether to uphold the Planning Commission's decision, the council may consider the effects or consequences of denying the variance. SB 9 entitles my client to build 2 800-square-foot homes on his property within 4 feet of the property lines. This would result in more impact on the neighbors and be less compatible with the neighborhood, and this should be considered in your decision tonight. Finally, Ms. Aitchison appears to imply that your decision will set a precedent for future SB 9 variance applications, and you can be assured that is not the case. It's settled case law that each variance application is unique based on its own facts and may not be used as precedent for future variance applications. So in closing, we urge you to uphold the Planning Commission decision and deny the appeal. Thank you.
Thank you very much. I'm going to bring it back to council for questions to the applicant and his representatives. Councilmember Widmer, do you have any questions for this point?
No, thank you very much.
No, excuse me.
Applicant,
No,
I'm
it's not
sorry.
the applicant. Thank you. You're the appellant. It's a little confusing, I know. Even we got confused
Get new
earlier.
names for this.
So, Vice Mayor, do you have any questions?
Got it.
Do you like to make that comment public? No, okay, fine. All right. Little sidebar there. How about you, Mr.? Okay.
I did have a question. One of the requests that was asked by the appellant was whether or not you could shift the structure closer to the border of Atherton. Did you consider that, and was that restricted because of trees, or what, how did you settle on? And I'm not saying you have to do that, I'm just curious what your thought process was in
The
that.
setback on the side opposite of the neighbor, that's 26 feet for the main house. This idea of it being 10 feet because it borders San Mateo County, I've never heard of anything like that at all. I have to stay 26 feet off.
This is Town Planner Brittany Bendix. That's correct.
Yes,
There is no
Brittany?
special setback if you're adjacent to another jurisdiction. It's still whatever the town setback is. And you might require that kind of conversation coming up in our multifamily development standard conversations with properties that are adjacent to other zoning districts. You don't get to apply the next jurisdiction standards. You have to meet Atherton standards.
With one limited exception, I believe accessory structures.
Accessory structures,
That's correct. And in fact, we did put the ADU on that side
right?
as a way to give more relief to Mr. Templeton.
Okay. Okay, I have a question, comment, I guess observation. What I've heard, or I feel that Mr. Templeton is feeling is that his privacy is going to be impacted because of this new house facing his backyard side property line. And although there's a tremendous amount of mature screening now, I don't think that's really a reality. However, the applicant has, I think, tried to remediate any kind of glaring window line by screening the lower portion of the upstairs windows. But I was wondering, is there, I don't know, I'm having a hard time reading the plan a little bit, but it looks like the second floor kind of goes straight up. Is there any kind of setback on the second floor from the first floor? Just to kind of give a little bit of more of an articulation and maybe a sense of, you know, that being pushed back a little bit.
Yeah, we did not design it that way. It is, we maintain the 26-foot setback on both the first and the second floor. There is the porch that kind of comes out a little bit, so it does appear that, and you can see that in the elevation, that
Okay.
there is a little bit of a wedding cake type of idea where you
Okay.
go up,
Yeah.
that,
Yeah.
you know, sort of
Well, it does set
screens
back a
it a
bit
little
then.
bit. It's not 26, you know,
Okay.
it's not just a straight line all the way up.
All right.
So
No.
there is a skirt roof around it and a porch that sort of brings it down to a more pedestrian scale on the first floor.
Okay, I can see that you've put a lot of thought into that. Okay. You
Question.
have a question, Councilmember Widmer?
Yeah, when I'm looking at the plans that are in the
Me.
presentation that Brittany put together, and it shows, I guess it's chart number 4, and next to where the new building is, there is, it looks like parking for 2 cars, is that correct?
That is, we're showing just a flat gravel area where we could put 2 cars in the front.
So there would
instead.
actually be 3 cars facing Mr. Templeton's, potentially, because that's.
I
it's
mean,
shown
well, there
as a
could be
parking
one
spot.
inside the garage, right?
One inside the garage and then 2 in
And there
between the
could
2
be
buildings.
2 spots there in the front. Mhm. It's just a flat gravel area.
And, okay, so got that covered. Then there is the, you know, the matter of the door that they brought up. And is there any reason why the door couldn't have been moved to be entering over where the patio is in the back of the new home? Well, you have a big patio there. You just walk right up. I'm just looking at this.
I think by the code, we are allowed to have the door where it is.
Well, I know it's by the
that's-
code you can do it.
No,
yeah.
no, 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 but I
Well,
think,
but
so-
if I could, because when we were doing the ADU discussions, okay, or being able to build an ADU on top of a garage, we said that the management of noise and light and things like that to the neighbor is most important. And so if you look at some of our ordinances that we have up there, we ask people to not have that, not have doors facing the neighbor, not have windows looking down into the neighbor, which, you know, of course, you're addressing with the half visible window. But we had those things, then they've been written into our code for over a year. And so I'm a little bit
I do think if
wonder
you look-
why we have to have a door facing the neighbors, especially as is one of his big complaints.
So when we talk, I was open to continue the conversation. And although I do not want to do that, I'm open to that. I think what I felt during the process is that all the concessions we made was never enough, was not enough. So he wants to paint the house in green. He wants for us to use the driveway from the neighbor's property. So everything that we think is reasonable, we are all in on it. And we demonstrate that during the process, and we are still open to that, right? But I did not, I could be wrong, but I did not feel that he was willing to give any concession or discuss anything. He was like, he wants like just to go to the appeal.
Right,
So
so
it-
we decided not to make a bunch of changes trying to guess what would satisfy Mr. Templeton. So we just went with what had been approved by Planning Commission
Right.
and decided to,
Councilmember Winfrey, can I ask you a question?
Sure.
Because I'm looking at this plan
Yeah.
And it looks to me, is there a front porch on the front of the house there?
It is a low wood deck.
A wood
that is
deck, and
about-
then you have the entry, and then there's the stairs to the right.
That's
of the-
correct.
So the
that
entry is
entry door-
actually recessed quite a bit
It is.
from the front of the house.
So
Do you
it's,
see what I'm
it's the
saying?
26 feet plus another 5 feet back. So that'd be about 31 feet back
Yeah,
for
I
that
see
front
where it
door.
is. I just
So,
read in the
under-
applicant's or in the appellant's question is that having the noise, which is something that we had spoken about with
Understand.
ADUs and with garage ADUs, was something that we felt was obtrusive.
But I think that those ADUs are closer set
Well, okay,
onto
well, but that's
the-
my
the
two, that's
property
my two
line.
cents. And the other thing that I hear is that, you know, well, we were told that if they don't want to negotiate, if he's going to appeal, then we don't have to take any of his suggestions. I don't think that that's a great way to go.
well, I
I
do think
don't
that
think
we
that's what they
provided
said.
the
It's not what they-
second floor screening. We thought that was reasonable and that, you know, we really were trying to cut off any type of sight line. So we did provide the second floor screening.
Okay. I'm going to close this portion and ask if there's any member of the public who would like to come and speak at this time. You have 3 minutes to make a comment about this. Member of the public wish to speak? Seeing none, I'll close that public comment period. Thank you. And we will proceed with closing comments by the appellant. And you get 5 minutes, sir, to speak.
Okay, well, I just want to say a couple things. One is, you know, I've experienced living there for quite some time when these people were when the applicants were doing all the remodeling, and it was really noisy. And people talk about taking care of their neighbors, but the reality is they don't, okay? There were cars, basically that whole driveway along by my house was used as a access to the house there, and there's a lot of noise there. You know, these gentlemen talk about being good to their neighbor, but just the other day, they did a bunch of yard work out there. And people came in there with their weed eaters and destroyed part of my front grass that I used to take care of the 30-year-old pear tree that I have. They just came in there and zzz, 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 all the grass is just blown away and gone everywhere. And I don't have a good feeling that I'm going to experience success there. I'm going to be going through, this has been for 3 years. I mean, the first year they did it, the owner remodeled it. The second year, Andre did it another year, and then he had to do it again. So it's been going on a long time, and it'll take a long time for them to do this, okay? The other thing is justice. I'm really concerned about, justice being done. You know, you know, this is a variance, and it is a self-inflicted problem, and I'm really concerned that nobody's doing anything at all to accommodate me. The planner says, let's go, you know, you could, some of my suggestions were to you know, why, you know, what is the cost-benefit relationship? You know, why is that a driveway there? Why is that long driveway? Do you really need it? Is it worth the garage back there? There seems to be very little benefit from their point of view, but a lot of cost from me. And as I said, the appearance I have is the front of their house is facing my backyard, and that's really what I feel, and the setback should be a lot larger. So let's see, what else? I also, please refer to, I don't know if you got it, Jennifer Atchison sent you a note here. She's a neighbor and an attorney reviewing a lot of the application and, you know, why exactly some of these claims by the town planner are not legitimate. So I wish that you would refer to that, because she rebuts almost every one. And why, first, the size of the property is unique. It's not, it's a self-imposed issue that he created, that was created. Anyway, so let's see, what else? I'm sorry, got my train of thought. So like I said, I'm really concerned that, the whole process didn't involve me. It's been going on for over a year, and why not? I feel like they're either hiding something or didn't want to work with me to get it done. So I think that's really bad. As to, let's see, there was one other point I wanted to make. I forgot. Let's see, did I write it down in the back? Yeah, the planning commission, there was nobody who showed up for the planning commission meeting, okay? And if you go review it, you can review it on the web. There was no consideration from the planning commissioners about concern for the privacy of me, the applicant. I mean, it was like, there's nothing there. And in fact, the other concern I have is if you look at it, you're signaling for time, I see.
Yes.
If you look at it, there was a discussion about how the density of our area is going to approach the density of unincorporated Menlo Park. And if you look at it and you do a fair comparison with putting the 3,100 square foot house that's at 94 Palmer Lane with this nearly 3,000 square foot house with 800 square foot, it matches exactly the density in unincorporated Menlo Park. And you are turning basically Atherton into unincorporated Menlo Park. And you are denying basically some of the basic plan of this area, which is kind of a rural free area. And as I said, the important thing is, has anyone tried? They never tried to do justice for me. I just,
Okay,
and
excuse
this
me.
is a variance.
This is an opportunity for you to respond to the testimony of evidence, but not to introduce new testimony
Did
or
I? Okay.
restate things that you've already restated.
Okay,
So, thank you.
okay.
All
I
righty.
guess, have I used my 5 minutes or, okay.
Okay.
Thank you very much. I really appreciate it.
I
Yeah.
need to ask the city attorney a procedural question at this time. City attorney, am I supposed to ask the applicant to give 5 minutes also?
The applicant does not have an opportunity for a rebuttal. It's just the appellant in this case.
Okay, thank you. I was unclear about that.
Can I just say
And so, sir,
I decided that after going through this, that I really need legal counsel, to someone to represent me. And I'm hoping, I was hoping that you would grant me like a 60-day continuance so that I could, people can't come right away. A 60-day continuance so that I could engage people to come and at least who know the law and could, I'm just an engineer and could maybe represent my interests better than I can. And I know that I just thought I'd go through the whole spiel, and I know there may be objections to that, et cetera, but I just wanted to say, maybe you could consider a continuation for 60 days, and I could retain some legal counsel that knows much more about variances than I do and can
thank you.
support my idea. Thank you.
Thank you, thank you. Okay. So at this time, I'm going to close the public hearing and ask.
Mayor Lewis,
Yes.
I do want to point out for the record that the council did receive earlier today a written comment letter from Jennifer Aitchison that is part of the record.
And it was from her as a legal representative, or was it as an individual?
It was on attorney letterhead, but it was provided in her capacity as a resident on Palmer Lane.
Okay, all right.
We just got a message while the gentleman was speaking from Jennifer. She's online, but it was after we'd closed public comment, so.
I don't think we have, yes, we're closing the public comment period, so I'm sorry, I get her. And we're going to ask staff to provide any additional background or address any issues that were raised in the hearing that you want to bring forward at this time.
Town Planner Brittany Bendix. I wanted to clarify that the affidavit indicates that the mailing was put in the mailbox on May 16th. Staff gave the distributor the copy of the notice on May 12th. Which is the Monday in advance of that Friday. That's standard process. The reason that we do it so far in advance, that's set by the Almanac's publication schedule because the notice is also published in the Almanac. I already touched on the notion that there aren't special setback requirements if you're adjacent to a property in another jurisdiction. I think those were the two major issues I wanted to raise.
Thank you, Brittany. I'm going to bring it back to council and ask if there's any questions that you need to ask and or want answered before we deliberate on the appeal. It's being
But not
comments. Okay. Love your comment.
Okay, my comment is, I think that the appellant raises a number of very important points. The issue of these kinds of lot changes adversely impacting Atherton's character is accurate. There are a number of degradations that are happening within our community, all of which are allowed by and in some cases required by the state legislature and the laws that the state legislature has passed. And we've spent a great deal of time over the last 3 years dealing with those issues to our consternation. And we are adamant that we will comply with state law. That doesn't mean that we think it's the right answer, but we are compliant with state law. And we have worked very hard to approve a housing element that complies with that, including allowing for the reduction of lot size. And my understanding is that everything that has happened from the applicant's perspective here is consistent with those laws. And in fact, I think that there's adjustments that the applicant has made that are respectful of attempting to maintain as much character as possible, because it is true, they could have put an ADU 4 feet from the property line. And we know that's true throughout Atherton, and it's something we've had to deal with, and we've, I think, responded to that in the most intelligent way that we could. But the bottom line is that's the law, and there's not much you can do about it. So I really have two comments. One is, I think it's really important to separate out what is required by state law and what adjustments could be made to address what feel like invasions or incursions onto you. Because all of us who live in this town experience, as new properties get built within these allowed requirements of state law, that they're invasive, and you end up finding property and buildings that are extremely close to what used to be open space. And that's just the way it is. So I think it's very important to separate out changes that you can seek to get made, like if there are screening solutions that can help, or there are other adjustments in the property that can help. Those are not, they aren't against the state law, but people want to be reasonable. And I listened to what the applicant said, and I think they were willing to make some changes, but you only are going to get changes if it's going two ways. So you have to be willing to agree to a compromise in order to get a compromise. If you don't agree to a compromise, you're going to end up with a situation where you're stuck. And unfortunately, that's where we're at right now. I don't think that means, just as advice to you, Mr. Templeton, that there isn't some room for improvement. But because I heard the applicant say there is some room, but I also heard the applicant say there's only room if there actually ends up being compromise. So, and I don't think that's unreasonable. So, so that's my judgment on listening to this and listening to this in a judicial capacity, because that's kind of the framework from which we look at this kind of an appeal, is from a judicial perspective, which is quite different from our normal perspective here on the council. And I think it's unfortunate that you weren't able to come to more of a resolution, because I think it's there. I think it's possible, and that's just my perspective. I also think that it's still possible to get something, but it's only going to be obtained if there's real compromise where both sides agree to let it go and work together. That's it.
Councilmember. I think Councilmember Widmer would like to say something now.
Yeah, I think that, as Rick said, I think that there's rooms for improvement and there's room for compromise on your side, Michael. And I would hope that in the coming days that y'all would talk about those, as opposed to us say, hey, you know, the only way we're going to support this, or the only way I'll support it, is if you guys do this. I'd prefer that you all work that out. Sorry that that we hadn't gotten to that for the Planning Commission, and that Michael wasn't there to raise his issues. But I do think that there's still some compromise to be had. Not 100%. You know, I don't see you painting your house green, for example, although I understood his position, why he wants it. He just doesn't want to see your house, but that's a little bit overstep. But if you could do things to protect his privacy, I think that be something that not only makes this moving forward a good thing, but it will allow the years to come to not be issues. And I don't think you want to have that. So, thank you.
Thank you, Councilmember Widmer. Mayor.
Yeah, I think I agree with what Bill and Rick said. I think a lot of your issues are stemming from this being a SB 9 lot split, but that is legal. I mean, that's state law. It's also our code. And so that is, I think you have to work within the bounds of what is reasonable to ask them to do. And with this lot split, there was no way for them to actually build a home without seeking a variance. And I think they have put a lot of care into trying to respect your privacy as much as he can. And it sounds like he did not have to meet with you after the planning commission made their judgment, and he did. And I'm disappointed that you guys weren't able to come to some resolution in that room to make it work well, because you guys will be neighbors. SB 9 lot splits require you to occupy one of these new units. You guys are neighbors. And so finding a way to work together and be neighbors is, you guys should be working together to find solutions. I don't think what you have designed is outside of what is Atherton standards. I think when you look at these lot sizes, having it fall within the R1A variances is challenging, because the lot, even before the lot split, was smaller. So to me, I look at it more, I asked staff, how does it compare to R1B lots within Atherton and what their standard code is? So those are our smaller lots, and variances that you have asked for, the setbacks you've asked for, exceed what is required for R1B. So to me, that still puts you within what is a reasonable request within Atherton. So I hope you guys meet. I hope that after this meeting, you guys are able to come together and find some compromise to be good neighbors, but I'm more in favor of supporting the planning commissions.
Thank you, Vice Mayor.
Mayor Lewis, if I can.
Yes.
We do have the resident Jennifer Ashenson online. She claimed to have an issue during the public comment portion. It's 3 additional minutes if you want to grant her.
I'm sorry, is Jen wanting to make a public comment at this time?
Yes, she does.
Lona, is that okay? I think so.
I think, Madam Mayor, if you reopen the public comment period, you reopen it for everyone
Exactly,
to
yeah.
speak. And you've already done that and closed the comment
No,
period.
okay.
And you have received written comment from this individual.
We're going to have to deny that for procedural reasons. We've already gone over our limit at this point. But I think my fellow council members have been eloquently speaking and summarizing where we are in this process. And from a personal point of view, because I did go and walk the applicant's property, I can tell you that I think the appellant will be much happier with the development when it's finished than the condition that it's in now, because it's very, very run down. And I think that you, as a neighbor, will really feel a benefit there. I truly believe that the applicant has been open to compromise and trying to work within a reasonable framework to minimize the impact. And his architect has demonstrated that. I think they are continuing to look at ways, maybe, but I really think that we should move forward and deny the appeal. And so I will make the recommended motion. I move that the City Council deny the appeal and uphold the Planning Commission's approval of the requests from and front and rear setback variances and tree protection zone exemptions to construct a new single-family dwelling with detached garage and attached ADU at 94 Palmer Lane, APN 060-163-290, and categorically exempt the project from the provisions of the California Environmental Quality Act, CEQA, and under AMC Section 15.32.100 and CEQA Section 15304, minor alterations to the land. May I get a second?
Second.
Second from Vice Mayor.
Mayor Lewis, I'm
Yes.
sorry, can your motion also affirmatively uphold the findings of the Planning Commission in support of the variance?
I think I said that in the very beginning. I move that the City Council deny the appeal and uphold the Planning Commission's approval of the requests for a variance
Based on the findings made by them.
based on the findings made by them, amended. Can we make that work for me? Does my second concur? Thank you. Do we need a roll call vote or just a voice all in favor?
Voice is fine.
All in favor?
Actually, I'm sorry, can we do a roll call because this is an appeal? Thank you.
Fine,
Sorry.
roll call. Thanks, you city manager. Okay, Anthony.
Councilmember DeGolia,
Yes.
Councilmember Widmer,
Yes.
Vice Mayor Holland,
Yes.
and Mayor Lewis.
Yes,
Thank you.
motion passes unanimously and there's no nays or abstentions. And the public hearing has been ended. Move on. Thank you all. So we're going to go on to item number 9.
This should
And-
be a fairly
yes,
simple
Anthony.
item. As you know, the Environmental Programs Committee has had 2 vacancies for quite some time. We received an applicant from Ms. Sophia Tang, who's online, and I will give her an opportunity just in a moment. The first vacancy was open from June 2024, and the last vacancy has been open for a little less than that. And as you are also aware, we received a resignation from the current chair, Amy Farrell, because she will be moving out of town. I will note that leaves 3 potential terms that we can appoint Sophia if council so chooses. And she's already indicated that she'd be open to the term that expires in June 2028.
Oh, okay.
So she provided that guidance. She is online and she said that she would be able to attend tomorrow's Environmental Programs Committee if
can?
appointed. She can.
Okay.
Okay. Um,
Good, because not going to attend, I understand.
yeah,
That's
Amy's-
correct. And
Amy's-
staff actually had an opportunity.
Meeting unless we appoint her.
That's also correct. Staff had an opportunity to sit with Sophia in person. We provided her with some guidance and updates on the EPC history and some current topics that are being taken into
Does she want to
consideration.
speak?
She does.
Okay.
Just give me 1 second here. Sophia, you have the floor.
Good evening. Good evening, Honorable Mayor Lewis, Vice Mayor Holland, and members of the City Council and everyone that's here today. My name is Sophia, applicant to the Environmental Programs Committee. First of all, I would like to say thank you to all of you for your presence. And please excuse my English because I just got relocated to Atherton from Vietnam with my 2 sons, William, 5 years old, and Anthony, 2 years old. It's my great privilege to call Atherton my home, and I feel a great sense of responsibility to contribute to our beautiful hometown. And my father has lived here in the city of Atherton for almost 20 years and in the United States for 50 years. And he has never stopped contributing to communal contribution. And I would like to follow his footsteps and also be a role model for my sons. In Vietnam, I worked in several different fields like manufacturing, digital media, and also in real estate. And after talking with Christabel, studying the Atherton's CAP and the work of the EPC, I found many parallels with my own experience. For instance, in manufacturing, I've built factory and also my company around environmentally conscious goal. We install industrial wastewater treatment system, and we planted a lot of 99 Florida royal palms and around the factory. And also we always strive to use recycled paper and minimize the use of virgin pulp paper. For my time at DPM, the digital media company, we built platform and create contents for kindergarten schools and elementary schools in Vietnam. And sustainability is always our core value. We created educational materials for children, encourage them to love and protect nature and wildlife, and cultivate a love for our planet, animals, and trees, and teaching them how to save energy and recycle. And for my work in the real estate business, we've used induction stove and also energy efficient LED lighting, and we use ceiling clothes drying racks instead of dryers. So Yeah, all in all, I've never officially been on a committee like this, but my work, my background has been involving sustainability, and with my current relocation, I think I'm going to be a good contribution to the EPC.
Thank you so
Thanks,
much,
Sophia.
Sophia. My goodness. Do you have a twin? Someone, we're looking for as many applicants as you. So I'm going to bring it back to the council members if they have any questions for you. If not, we will deliberate. Any member of the public have a comment about Sophia's application to our Environmental Programs Committee? Not, I'd like to get a motion to approve the acceptance of the application of Sophia Lin Duong to our Environmental Programs Committee. And I understand you are looking at the full 4-year term or 3-year term to
3-year term.
3-year term. Yes,
3
3-year
years.
term.
Yes.
Thank you very much. So do I have a second?
Second.
Vice Mayor second. Any comments from the other council members? All in favor?
Aye.
Aye.
Thank you for signing up and raising your hand to be
We'll see you tomorrow.
town committee. We'll see you tomorrow.
Do you know there's a meeting here tomorrow?
Yes. The meeting is at 1 tomorrow.
Okay, great. Thank you so much. Thank you so much.
Thank you
for
very
waiting.
much.
Okay.
My honor.
Okay. Our honor too. Item number 10 is where's our chief when we need him? There he is. Okay. It is.
Best behavior tonight because I have my
adoption.
father visiting from Seattle.
That's your
Large-
father visiting from
Sure.
Seattle?
Obviously, in
Well,
large part
welcome.
responsible for me being here, so.
Great.
He's gonna be here for a few days, so I'll be very professional.
I'm just going to tee you up a little bit.
Yes, ma'am.
The chief is going to present a resolution to adopt the residential permit parking program on Maple Avenue between Station Lane and El Camino Real, and on Ashfield Road between the Town Center and El Camino Real. And I think we lost some of our Maple Lane and Ashfield residents, but we'll proceed on anyway, won't we?
We will. So to read the resolution, or do you want background first?
No, just get us to vote.
We're losing our guys.
Had a whole study session. So.
I would do a very brief overview along with any changes you want to make to the resolution.
Very
2
brief, and I know
minutes.
that you're very familiar with the issue, but thanks to your vision of the beautiful town center and the library, which has become very popular, it has gone beyond the capacity of the parking availability and created quite an issue on Maple Avenue and Ashfield Road. We had 20 or 30 residents attend the last Transportation Committee meeting in May. And as a result of that, the committee recommended to you to establish permit parking on Maple and Ashfield. And then at your study session earlier this month, we had several residents again voice their concerns, which you listened to very intently, and made the recommendation for us to come back to you with a resolution for permit parking, which would be Monday through Friday, 9 a.m. to 6 p.m., holidays accepted, and vehicles that would be exempted to make it easier on residents would be delivery vehicles and service vehicles like landscapers, pool maintenance, etc. So with that,
Do I have any questions? Yes, Vice Mayor.
So I understand the idea. I'm supportive of service vehicles being an exception, and I think gardeners, pool, construction workers, it's very easy to see what those cars are. It's the inclusion of childcare.
should not have been included. That would not be an exempt because there's no way for us to
I
know.
was gonna ask, how do you know?
There would be no way for us to know, so that should not have been included.
So it's basically like very obvious trucks.
Correct. And then obviously, in our code enforcement people, they'll receive the training, not that they need much, but they know using their discretion, rather than just write immediately the ticket, could this be something that's related? If we have an indication, we're not going to go house to house, but maybe this. But if there is no indication, and I think the residents have been made clear about that this is a two-way street, you made several comments to them too about how this is going to work. We will make it work, and the residents have been great getting back to us with their recommendations, so we will make it work. Each resident's going to be receiving a letter with 6 permits each, and also instructed how to get temporary permits if they need from dispatch 24 hours a day. So I can't imagine that a resident's going to have more than 6 people on a Monday through Friday. I don't know. But again, we will make it.
I do.
I'm not that popular, so.
Yeah.
Okay, any other council member have a question for the chief? Oh, Vice Mayor, go ahead.
Just want to make sure we're clear. So since we are creating these exceptions, if someone gets ticketed and they are some kind of undercover pool maintenance, some kind of maintenance type person that falls within the exception, is there going to be a appeal process for them to get?
It's up to the court. So once we issue the ticket, it's sent to the court, and like anyone else, they have to go to the court and would have to appeal. There's
This is
nothing, I can't
serious.
undo it once
Oh.
it's done.
It's not like a, you know.
Right. But just to be clear too, we're not gonna be out there ticket. I mean, that's not why we're here. So we're just here to make their lives better for the residents, and we will work with them and we will make it work best we can. But at the end of the day, if there's a violation, the residents have been told,
Okay,
it'll be ticketed.
so I have a question now.
Yes, ma'am.
Are we also going to be posting resident parking only signs or
Yes, so
other
we're
kind of
working with Public, where
signs?
Public Works is, we'll be making the order once we have the decision, so we know that the hours have been approved. He'll be ordering the signs, and once the signs go up, there's a 2-week grace period of enforcement. That's where we'll start doing our education and our outreach, giving them time to get used to it. And then after that period, we'll be moving forward, and there will be proactive enforcement. We don't typically do that in town, as you're aware. It's
Okay.
typically complaint related, but we will be doing proactive enforcement until we feel that we've gained compliance, and then we'll probably go more towards complaint-based.
Up to the public for any public comments, questions for the chief on this? Anyone online? No? Okay, not yet. Oh, I think Councilmember DeGoya has awakened and he has a question.
I'm not awakened. I hadn't been asked.
Do you have-
Okay. I understand that the parking citation fee is $41.
That's correct.
And does that cover costs?
It's not designed to cover costs. It's a penalty.
Oh, but you can't make the penalty more than the costs, right? Or tax.
Yeah, and plus my understanding, these fines are based on.
So you can
state
make
of
it anything.
California. It is. It's from the state of California, so they dictate, I believe. I forget
Wait,
the-
it's from the state of California that a parking fee is $41?
So the state sets up, and I'm used to Washington State, I'm not sure what the
From
entity is
San
called here.
Francisco.
They set up the fines for speeding, failing to give the right of way, running a stop sign. Those are set by the state that we adopt.
Vehicle code fines, in which this is.
That's odd because I've gotten parking tickets that are far more than $41
Yeah, and,
in Stanford.
well, that's private.
Well,
Yeah,
because
that's-
they,
Well,
That's
this is
uni-
private property also.
No.
Yes.
That would be a university, so. We're set by the guidelines from the state.
Okay. I'm ready
So-
for a motion.
I have another comment I want to follow up from what the vice mayor said. I was looking for the language in the staff report, but I didn't find it. But I thought there were a couple places where it mentioned that the permit would be for residents and for nannies and caregivers and
Yes.
pool service providers and landscapers and contractors.
So that was in my pre-agenda email.
Oh, that was in your Friday email.
Pre-agenda one for today, and I misspoke about nannies and caregivers. Those won't be exempted.
Right.
But as the vice mayor indicated, vehicles that clearly say Joe's Pool Service or something like that would be
Yeah.
exempted. And construction vehicles pursuant to a construction operations
Okay.
plan.
So that's where it was in the Friday, and we've agreed that's wrong.
Okay, I'm bringing it back to council. I would like to have a motion on this item. Anyone want to make a motion?
Can I ask a process question? Because in your email from earlier, there's the written exemption.
Yeah, we need to make an amendment to the resolution to specifically state what we're exempting. And it can read something like it's recommended that delivery and service vehicles are exempt from the permit requirement, provided they are parked solely on the frontage of the premises to which they are providing service. This includes pool cleaners, gardeners, delivery vehicles, and other similar vehicles. Construction-related vehicles are also exempt, provided they are parked pursuant to an approved construction operations plan. So that statement would be incorporated into the
Into
resolution.
this resolution here.
Correct.
Make a motion that we adopt the resolution to implement a residential permit parking program on Maple Avenue between Station Lane and El Camino Real and Ashfield Road between Town Center and El Camino Real.
Second.
It's moved and seconded. Any questions, oppositions? All in favor?
Aye.
Aye. Any opposed? Motion passes unanimously. Okay, moving on to item number 11. Review the recommendation from the Park and Rec Committee regarding pickleball program at Holbrook Palmer Park and provide direction to staff. Robert, hi, Avadia, Mr. Avadia, yes.
Thank you, Mayor, members of the council. So I'll give a brief report. The town initiated pickleball at Holbrook Palmer Park back in January of 2024, and it has seen some success. And in September of 24, the city council extended available hours. The current hours of pickleball usage at Holbrook Palmer Park are mornings daily until noon, in the evenings after 4 p.m. on Tuesdays and Thursdays, and all day on Sunday. So those are the current pickleball hours. Demand has continued to grow since we started the pickleball trial and is exceeding 200 hours a month on the 2 courts that we have. So that is fantastic. We're getting great usage of the courts at the park. There continues to be driving demand and desire to increase pickleball, both by by our residents and users of the facility. And the Park and Rec Committee looked at various alternatives, and Councilmember DeGoya at one point was approached by a potential donor to help facilitate improvements to the pickleball program. Attached to your report are various alternatives that were presented to the Park and Recreation Committee. I can share those on the slide if you'd like. But those range from permanent conversion of court number 1 to 4 pickleball courts, conversion of the clay court to a hard court to mitigate some of the tennis usage, given the relatively low usage of clay at the park, as well as alternatives considering the removal and replacement of the handball courts. Initially, the Park and Recreation Committee received a presentation back at their June meeting. They followed that up with an additional conversation at their meeting earlier this month. Ultimately, their recommendation is, as a short-term solution, rather than the 2 overstriped courts that we have now on Court 1, is to convert that to 4 overstriped courts. And what that means is retaining that underlying tennis court. We would have to basically paint over the existing striping of pickleball, where we have 1 court on each side of the net, and then repaint with 2 courts on each side of the net. And that would be a short-term way to basically double the available courts that we have, leaving the current hours the same. And then they had a longer-term recommendation wherein we'd look at having somehow funded by somebody the removal of the handball court and replacement with 2 independent pickleball courts. So there are some rough costs, order of magnitude, provided in your staff report. I'm available to answer any questions and or present things on the screen to help facilitate
so much.
conversation. So I do want to highlight a couple other items. So right now, there is no drop-in or open play. The recommendation from the committee was not to add that at this time. And then there's also been interest by both residents as well as a resident instructor to provide instruction at the pickleball courts. Currently, due to the limited number of courts, we have not permitted instructional use at this time. That includes player capital not providing lessons. And so the council conversation can include, do we allow instruction? Is it solely to player capital or is it open to others? And that would potentially, the recommendation would be is if we are opening the opportunity for an alternate instructor, that at least they obtain a business license from the town. So.
I'll bring it to council for any questions to Robert this time. None? Yes? Okay.
So if an instructor applied for a business license, would that include insurance coverage for whatever liability they might have for doing instruction in the park, or?
Right now,
It's like a
the
normal
answer
business
is-
license doesn't have that.
No, it wouldn't.
So we would create some
And
kind of special.
The only way to do that would be to have some sort of agreement or other,
Theoretically, if they're running a business of teaching instruction, they've got insurance for that, but there wouldn't be any town insurance associated with their provision of instruction.
They could show proof of insurance,
that's
business
fine.
insurance. I think that's what she's
Yeah.
asking.
Yeah, that could be a requirement, but
Yes, definitely. Comments or questions from council?
Yes, for questions.
Yeah, questions. Yeah, I haven't gotten. And there's a person online who'd like to question. Open up to public for any questions.
Questions, any?
Questions or comments? Okay.
We had public questions, comments. We had public comments, but not questions.
Any
have anyone?
comments? Yeah, there's Laura.
Robinson's
Oh,
first.
Walter.
Walter Robinson, you have the floor.
Okay. Hi, Walt.
Good evening, council. As you may remember, I've been involved on Park and Rec for this whole time, ever since we started doing pickleball. I've been on the subcommittee. I've analyzed things right and left, and I want to just put a little more information out right now. First of all, the recommendation includes not only for pickleball courts, which frankly was requested by pickleball players and basically solves all their issues. They just wanted more courts and therefore more court time. We added to that, that in fact, we asked Michael, Player Capital, couldn't they somehow redirect tennis players so that if there's another court open when they want to play, have them go someplace other than one, and at that point, anybody could play pickleball. As long as it's open, come on in on Saturdays, particularly because at that point, and this is a Saturday issue, that was the main complaint. 3 Saturdays in June, there was no availability in the morning. And that's what prompted all of this initially. So we solved the problem in 3 ways. First way, restrike. Second way, Michael will, at his own expense, and this is staff time for him, redirect the reservations so that if somebody says I want a Saturday afternoon to play tennis on one, he'll say, no, please go to another one. And therefore the pickleball players can use it. Thirdly, he also has a plan that we asked him to do that he could open up the court 1 for pickleball Saturday, or if it's not reserved for tennis by Friday morning. And again, Saturday's been the big issue. So we got 3 ways to solve that, which I think, and we would probably hear from some of our pickleball players. I see some there, but I think that's it. Second point, and that is the donor. And when we say short term, that's not really the right term for what we're proposing. It's immediate. This is immediate. This may solve all the issues, and we have nothing further to talk about except some unrelated issues. Secondly, the donor. We're very appreciative of a donor doing this. You may remember when we presented to you, I think last September, we had that as an issue. And it was encouraged for pickleball people to look if they could finance a separate court. There's no magic to where we place it, except it goes best. And you can see on the Roberts maps, the one called Highball Court. And that adds 2 on the side. And my proposal would be we also leave Court 1 double striped. So they want 4, if they built their 2 ones, they'd have total control over that for football. And we would then have also conversion of Court 1. So if they needed to have more at their times, they probably wouldn't need it as much. So we'd have more tennis there. Anyways, that would be the issue. On the initial donation, which was to take the clay court and to make it a hard court and then take away Court 1, take away from tennis. I don't think that works. You can't do that because they need 6 at a certain time. And I do want to point out that the clay court is used much more than is in the report. The report was accurate as to what was reported for only 3/4 of the month. In fact, 21 separate individuals, 21 people have paid to play on that clay court. And they played 32 hours in June, and Player Capital used 102 hours. So that court was used for all that time. And if you look at that and compare it to the 206 hours.
Walter, we're going to have to ask you to finish up.
Sure.
Thank you.
Anyway, no, that's and if you want our views on teaching, you can see that our view was that if they have 4 courts, maybe they could use pickleball instruction there and drop in. You looked at that last September and did not go for that. And as Robert says, we're not in favor of that. Thanks so much.
Okay. Are there any other members of the public wanting to make a comment?
There's no one else online.
No one else online? Bring it back to council for discussion.
There's nobody with their hand raised.
Shall we start with?
Sure, I appreciate it. I think the idea for adding, I was at the meeting 2 months ago in Rick's behalf, where the idea came up to turn court number 1 into 4 pickleball courts and make those permanent for pickleball, period, at the end. And I thought that was a great idea. It solved the need in having it opened all the time for pickleball players with reservations. So I support acquiring reservations, not drop in, putting the 4 courts there, and then that's it. I understand Mr. Jessup would like to keep the clay court, and as Walt pointed out, the usage has gone up on the clay court. I think we should keep that. Looking over all the other ideas, we don't have the money at this point in time to do the handball court. And so, there's really nothing going on with regards to that. I definitely am not in favor of the one where you've taken court 5 and go all the way over. With regards to instructions, my thought is that we should have Player Capital do the instructions. Right now, they have the right to do instructions for tennis. We could expand that. We could ask them for more money, and it would only be available if, in fact, there was a time slot open. I can't see having everybody and their dog bring their own instructor over. I just think that would become unwieldy, and we wouldn't be able to police, do they have a business license with us and things like that. We'd be back to the days of Alan Margot. I don't think that's where we want to be. So, so my feeling again, just in summary, take court 1 and make it 4 pickleball courts, leave that open all the time for reservations for pickleball only. Keep the clay court as it is, and we don't have the money for doing anything else in instruction. Let's leave it with our current tennis and playing pros, but include that in our upcoming negotiations with them regards to making sure they're leaving more courts open for tennis players, not just canceling them on the day of the playing. And if we can get the money for the ball court, we can address that at that time. Thank you very much. Thank you.
Councilmember DeGoya.
Okay, so I've got a couple differences with what Bill recommends. The Park and Rec Committee didn't recommend making Court 1 permanent pickleball courts all the time. It recommended adding 2 more courts to Court 1 so that there would be 4 pickleball courts there, but they would still be temporary pickleball courts. And that seems to satisfy the need that we currently have. And we have a need for tennis there during the hours that tennis is still enabled to be there, with the stipulation that Walt Robinson clearly stated, which is that Player Capital has agreed to manage the reservations for tennis such that if someone makes a reservation on Court 1 and that reservation could be moved to one of the other tennis court surfaces, then he would make that happen, and that would open up the Court 1 for pickleball reservations outside of the dedicated pickleball times, which currently people can make pickleball reservations on Court 1 if in a non-pickleball time if it hasn't been reserved for tennis. So Michael Jessup would increase that opportunity, and I think that's great. With respect to the handball courts, I think what we should do is we should solicit donations to convert the handball court. We shouldn't just be passive about it, but we should actively look for donations. And I was informed by one resident that she was interested in making a donation, which at the time was in the amount that would have been necessary to convert the clay court to a hard court. And I haven't heard back from her with respect to the handball courts, but so I don't know that the amount of her donation would cover the entire cost, but it would be substantial. And I think we should look for additional donations. There are pickleball people that would love to see 2 permanent pickleball courts made out of those handball courts, and that would just increase the opportunity for pickleball players. So I think that would be important for us to do. And finally, with respect to the instruction, my recommendation is twofold. Number one, that we require, I don't think we should limit pickleball instruction to Player Capital. We do have an exclusive with Player Capital for tennis instruction, but we've clearly heard from residents that they have their own instructors that they would like to bring. And I don't think it has to be anybody under the sun. I think we should require that they have the necessary insurance that the town requires. And I think we should require that in order for someone to instruct in pickleball, that the key holder has to make the reservation, not the instructor. And if the instructor is a key holder, which they certainly have the opportunity to be, they can make a reservation for their own use, but not for their instruction use. So we should make it a rule that an instructor can't reserve the court. It's the key holder who would be instructed that can reserve the court, and I think that would be fine.
Can I ask you a quick question? What's the nuance there, the difference about the key holder versus the instructor?
Oh, the nuance is that there is a resident who has been giving pickleball instruction and reserving 5 courts a week.
Oh.
And when he uses those courts, he does instruction, so he's making money from it. And I'm sure there's no insurance issue. Right? I don't know if there's an insurance
We don't
issue.
share in it.
But, yeah, and staff stepped in and stopped that so that and enforced that nobody could give instruction for pickleball, because we had so limited courts. But now with 4 courts on court 1, there'll be much more availability. But I don't think it's fair to have an instructor reserve 5 or 10 courts a week to give their.
Mayor? Opine on this?
Yeah, I agree with what Rick said. Nutshell, I think having 4 courts, striping seems like a no-brainer. It sounds like their capital has created a system where you can share with tennis and pickleball outside of designated ball hours. I don't know if that's public, that information on the website, or is that just like,
I think what Walt was alluding to, and maybe Councilmember DeGolia has some more familiarity with it, or Robert, but on their reservation system, they would just open up the pickleball court for hours that he's diverting for tennis. And then
We
they'd be able to
made it
reserve.
so that pickleball players, if court 1 is open during a non-dedicated pickleball time, that a pickleball player can reserve it or can walk onto it, right?
Right now, it's what, I'm gonna say, if any court is unreserved, a key holder can walk onto the court and use it until somebody with a reservation boots them out.
So this is more like if it's
If
walking
it's
up, it's
open.
open. You're not able to make a pickleball reservation outside of the pickleball designated hours?
Yeah, so right now, that is the case.
Okay.
You can reserve court, I can pull up the reservation system, but the way that it is that court 1 as tennis is closed for reservation while the 2 pickleball courts are available for use.
Right. And
When
flips.
the pickleball hours are not regular reservable, they are closed for pickleball reservation and open for tennis. The nuance that has been discussed is if somebody is trying to reserve that court for tennis during a tennis hour, if another court is available, that reservation may be moved by player capital to another court, theoretically leaving that court open for walk-on play.
Okay, but not reservations.
Not reservations, because that reservation hour
Very
is
difficult.
right now for tennis.
Right.
So when you hit that second or third attempt at reserving court 1, they'll have it for tennis. Because there's no other court for that person to go to.
Which in some way is actually drop-in play for pickleball. If they could just walk on court 1 and play pickleball.
So then pickleball player, can you tell I have not yet? Ball at Holbrook Palmer. So that means that like the pickleball community knows to basically look and see if court 1 is reserved, and then they know they could probably walk in, and this is like an established, if you know kind of system.
There's only 2 courts now for pickleball,
Right.
right? And so it's limited.
Right.
Yeah.
I think that's a good policy. I'm just like, how do you actually execute it versus having this be a like wink secret policy is what I'm.
Trial and error.
Right.
In reality, there's nothing to stop a pickleball player from
Walking in.
reserving court 1
As
during a tennis hour.
Right.
Because they're a key holder.
Yeah.
And showing up, and instead of bringing their tennis racket, they bring their pickleball
I
racket.
bet
There's
that
nothing to
happens.
stop that. I know it happens.
Okay. Okay. Yeah, I mean, I think having 4 courts is a great idea. I'm wondering if there's a better reservation system to
Probably.
not have this very complicated system that we were discussing at
Make
length
it, make
here.
it
So
pickleball.
I don't,
Make it permanent, you know?
Right. Make
So
it
that's
pickleball
the
all the time.
only solution,
yeah.
that the pickleball should be permanent. I wonder how, I'm stealing your
Oh, it's
time.
okay. This is.
Okay, sorry. My question is, how easy is it to switch from pickleball to tennis? You know, the restriping, Is it just throwing down, I don't know, like
Robert can tell you.
throwing down a
Okay.
piece of,
Paint.
it's
So
paint.
there's a big difference between what I'll call permanent striping, which is the exhibit that was attached to your
Got
thing.
it, okay.
And that would mean that we resurface the entire court, repaint it with permanent quartz.
Which I think we should do when we turn it into 4.
Okay. So the way that the court is now, you have the underlying tennis court is the predominant striping. And we have outline lines for the pickleball courts, one on each side. We can do the same thing with 4 courts. What that entails is us repainting those new stripes for the pickleball to match the underlying color of the tennis courts so that they're gone. And then we restripe for independent outlines, not colored stuff, but just the outlines of those 4 courts. And it's something that many jurisdictions do. I can think one example of that, if I recall correctly, might be Nealon Park.
I'm so
They
happy
just
we
have it, they have it done, I think, a little differently in terms of the direction of the courts, so we wouldn't do it this way. So here, if you can see that. You have the blue is the underlying tennis court, and then those, I think their yellow lines are the outlines for the pickleball, but we would put them vertically instead of horizontally.
Got it.
And so what that does in essence is still continue to allow for that dual use. So it's a choice that the council makes as to whether it remains as a dual use facility or if the desire is to convert it permanently one way or the other.
It's just so
Okay.
messy.
Page 6 shows the painting. Page 6 of the staff report shows the 4 courts painted on there, and there's no tennis, right?
Yeah, well, that would be if we were to make it permanently pickleball, there'd be no need to have that underlying
I think we'll get
tennis.
there.
And so
Maybe
you
not
would
this round.
resurface the
Okay.
entire
I
court
vote.
rather than just repainting lines.
I vote. Okay,
Wait, so you want to do permanent all pickleball?
Yeah,
on one
Skip this
court.
half measure.
yeah,
that
and
way.
it takes away,
Yeah. That's not what Park and Rec,
okay?
but it doesn't matter. I mean, we acknowledge their recommendation, but we're going to do 4 courts on one.
Yep. And it takes away any more discussion on it.
I think.
Takes away discussion, fine, but it limits the amount of tennis. The reason that they recommended keeping it as dual use is that the tennis players needed tennis space.
Well-
And, well, then forget the handball court. You don't need 6 courts.
Right, I agree, but the one thing, I think that when we have our next discussion with Mr. Jessup, we should say, just reserve 2 courts at a time, not 3, like you see up there. We've got all sorts of, taking over 3 and 4 courts. And then they release them the day of. Somebody who's planning on playing can't get on because they're not online looking all the time. Oh, did a court get open? I think that's one of the things. There's been a big demand on pickleball. I think we should go with 4 courts and make it permanent. That's my 2 cents.
I move that we pursue what Park and Rec recommended. And that we restripe court 1 with 4 temporary pickleball courts, and that we pursue a donation for the handball courts to pay for the conversion of handball courts into 2 pickleball courts, and that we authorize pickleball instruction but not allow the instructor to return to court. for their instruction. They can reserve it for their use. And that in order for the instructor to provide instruction, they have to get the insurance.
That's a big pull up all into one thing.
It's a motion.
That's a motion. So, I mean,
If there's not a second, then it dies.
I think that Elizabeth and Bill are right. We're going to end up with there's a need for more permanent pickleball courts. So I'm more wondering, should we restripe them temporary way for a mixed use, eliminate the hours and let the reservation, let it
Sort it out.
test it out, see what happens, and then just as needed later is kind of my
well,
view. Cheapest, fastest way.
That's true. I don't know how many emails I received from pickleball people, and it truly has become very, very popular. Town of Atherton, kind of build it, they will come. The problem is taking court one away from Player Capital. What will that do to his business model?
Not Player Capital, it's tennis key holder. You're taking it away from, not taking away from Player Capital. Player Capital doesn't.
Oh, they don't.
No,
Oh, I
Player
didn't know that.
Capital takes the
Court one is
three
used
over
by
here.
tennis key holders.
But can't
Player
tennis
Capital
key-
takes these
okay,
three
but
for the
can't-
most part.
Can't tennis key holders play on other courts?
Yeah.
Well, they can if they're available, but you're taking away that are currently used by tennis.
Walt would say.
It's 5 courts.
5 courts.
Players Capital uses, we should try and restrict them to 2, except for when they're having a camp, which, well, we're going to negotiate the contract in a little bit.
So if you wanted to engage Walt, I think he's still on the line. He's sending a couple of messages to me to kind of
Okay.
clarify a couple things, but if you want to re-engage Walt as the vice chair
Okay,
of the.
my concern just it looks so messy. I mean, do pickleball players mind that, or tennis players mind when it's got all these stripes going on? Have any problem with it?
Talk to pickleball players, they don't have a problem.
It's, like I said, it's not unusual.
Okay, well, I think we should go with what the suggestion laid out, because we can always adjust it later.
Before
Well,
there's a
We
second,
probably will.
Yeah,
I mean,
but let's just move this on.
Fine,
before there's a
I
second.
don't even remember what your motion
Oh, it's all encompassing.
So
I can restate the motion.
Good.
it's basically what Park and Rec.
It was-
Supporting it, that's
Pursue
fine.
I'll
Park and
second
Recreation's recommendations, restrike Court 1 with 4 temporary pickleball stripings. Pursue the donation for the handball courts, authorize pickleball instruction with the instructed only being able to make the reservation, and that any instructor get a business license. And my clarification on your motion is that the insurance be proof of insurance, not town insurance.
Yeah,
No,
proof of
that's what I
insurance.
meant.
Yeah,
With the
of course.
by town insurance, I meant the requirement that the town has.
Got it.
I'll second that.
I approve it.
All in favor?
Aye.
Aye. Ooh,
But in the interim, can you guys work with Player Capital to figure out a better way for our reservation system to work? If this like fluid pickleball happens outside of pickleball hours, happens anyways, like, is there a better way that they,
We can chat with
on their
Michael.
website, that could make this work a little bit more?
We can chat with-
All right.
We can chat,
reflects the-
that's direction.
What's happening?
Okay.
we can chat with them, but there are going to be certain limitations as to what
Right.
the reservation software
Right.
allows.
Okay, we're finished with the pickleball and tennis, right?
Right.
Me too. Yeah, okay.
We have the.
So we have one remaining item number 12, and thank you all so very much for staying with us and staying awake. And George,
Only
It's the-
8:20, you guys.
it's the Senior Task Force request for financial support for marketing materials. And George, are you going to tee up
I
Joanne?
will tee up Joanne. This is very, very brief staff report. Senior Task Force is coordinating event in September, and they're looking for funds from the town to assist with a mailer. The staff report outlines what we're currently doing under the current process for designated groups. And so the mailer is about $2,000, and that's their funding request, and they can
Thank you.
elaborate further.
And Joan's right there too.
Yes. Oh,
Well, we can get Ken up here
Okay,
too.
well, I'll make a motion.
No, that's good. Make a motion.
Should I make a mo, I'd like to hear Joanne speak. She speaks so eloquently, right?
Bill, I
Yes.
am going to try to stay within 3.5 minutes, okay?
3.5 minutes? Okay.
Don't time me, please. No, good evening. My name is Joanne Sokolov, and we are here for 3 purposes. First of all, to reintroduce you to the Senior Task Force Committee and to give you an update on a lot of work that's been done over the last 18 to 24 months. And then, as George stated, to ask you for some money.
Oh, always.
Ken, I just want you to wait.
Hi,
Ken
Ken.
Frederick, Joan Sanders.
Joanne.
And all I am is their sidekick.
Okay.
You know, that is our beloved grumpy man back there, and this is our gracious queen. So thank you for your
She's the
indulgence. and your
doyenne
time.
of Atherton.
As you know, the senior committee is a town-designated, resident-led committee and is not subject to the Brown Act. And it's an offshoot of the Center for Age-Friendly Excellence Project,
Cafe.
otherwise known as CAFE, that was undertaken, I think, maybe a little over 2 years ago. So we're going back a ways in time. The purpose of the original project was to conduct a needs analysis in concert with a CAFE consultant that involved collecting information, insights, and ideas directly from residents aged 55 years and older on what social, environmental, and health and lifestyle aspects of our community, Atherton, could be created or enhanced to better enable a healthy and thriving life for older adults. Elizabeth and Diana were council liaisons, and you provided in the early days and have continuously critical insights, suggestions, and feedback along the way. And we really want to thank you. And also staff who've been very patient with
Staff's
us.
Maybe our oldest people.
What's that? Oh.
That's not true.
I know that. I know
Okay,
that.
that's not-
You weren't on it, Rick.
You gave the oldest.
When we spun off and became our own independent thinkers, we proposed to council, and you all seem to be pretty encouraged and excited by some deliverables that we proposed, some of which were to develop an annual senior resource fair to be hosted at the town center, to look at how we might, in collaboration with the town, enhance communication activities and efforts to engage senior residents. And we looked at increasing information distribution channels using local media outlets, increasing in-person events, and identifying different means of programming. And it also included leveraging the use of the Athertonian to get word out about the programs that we are developing and offering. One of the other deliverables was to provide a resource center for seniors at the library. That has been accomplished. And I think what's so wonderful about that is that it shows collaboration and partnership. And it is kind of a physical representation of senior identity. You know, it's a place that people can literally physically go to, touch the books, pull them out, take a look. And so that provides symbolic importance, I think. A number of months ago, we provided a fall prevention seminar in partnership with Atherton Police and Kensington Palace. There was excellent attendance, and we received very positive and encouraging feedback from participants and requests for more seminars of that type. I want to say too that the word has gotten out to at least one neighboring city that what Atherton is doing with their senior committee is pretty cool. Ken has collaborated with some folks in Woodside to possibly look at dual efforts, kind of sharing resources and ideas, and also looking at the possibility of doing like mutual exchange, having events here, having events there, and then kind of bringing the residents of the two communities together. You might have heard that on September 27th, we will be putting a senior place expo on at Jennings Pavilion. And Ken, would you like to say a few words? Ken is really kind of the mastermind behind it. He has secured a guest speaker who has written this book. I don't know if you want to say a few words and give everyone an idea of who will be there, how they will be vetted.
Well, yeah, I'll make that very quick.
Okay.
So the goal is, for the sessions we had in this room, we had two of them, one, the falling prevention, another, both done by us, and Kensington Place had some work with it. We had a pretty good turnout, but small in my view for the number of seniors we got in the town. We got, 1,900 seniors, and we had like 30 to 50 people, half and half on the Zoom and half in person. So the goal is to find something that, again, as Joan was saying, that we're not reinventing anything anyone else is doing. Based on the work that the library did with putting that seminar, the list of assets together, if it's being done elsewhere, there's no reason why the town should do it. So there's a lot of stuff being elsewhere. And a lot of these individual symposiums can be done all the time. And so now we're working a little closer with the library so we can help them get larger numbers of attendees at their sessions. So the session on the 27th we've planned is a unique session, which is really for seniors and those who love seniors. What is your place in life at your age? Is the place you're in now the place you want to be for the future? Or do you want to have, or do you think you should be elsewhere? And it's something that people don't talk about a lot, but when you actually talk to them, it's behind their mind. I have not talked to anybody on this, and I've talked to a lot of people on this, who hasn't started out saying, it's not really it is a problem. Everyone thinks about it. And if something happens, like you lose a spouse, or something happens, it's too late to plan. You have to be planning now. So the whole topic here is to set up a session that says, what is place? Where would you live in life? There's a whole thing going on in senior living now about what is place. And the place is either you can stay where you are, or you can move, and I decide which. So this is a combination of presentation and expo. That is, we have guest speakers who are experts in the idea of what defining place, what does it mean to you? And if you decide to stay where you are, what you have to do in general to your house. If you move out, in general, what would you look at? This would be in the Jennings Pavilion, and then outside of the Jennings Pavilion, the plan is to have vetted individuals who talk about, okay, if you're going to stay in your place, here's the mechanical things you have to do to your house. Here's some ideas for it. Here's some things you could do about getting, healthcare services come into your house, all that sort of thing. And then also have representatives from the various senior living centers around the area, from pure independent 55 and living but nothing else, to just independent living, all the way through continuing care and dementia. The idea would be to have, again, nobody selling anything, nobody taking orders, but the idea says, tell me what a CCRC is. And have two people, we want two from every one, like the ARC, that can come and talk about what a CCRC is. So you get, in one case, you get Sequoia and then somebody else at the same time. In fact, one of the things we want to do is invite, if Sequoia is here, for example, have them bring with them somebody who used to live here in Atherton, is now there. So it's an unusual situation. And they have these things, as you may have seen every once in a while, in big venues with hundreds and hundreds of things. This is pretty small. We want kind of 50 to 100 people. Would like 100, but 50 would be the least. And I think we're gonna get that with no problem. And then we want about kind of 10 to 15 various suppliers that you can talk to. And we would do that at the pavilion from 10 to noon on a Saturday the 27th. And one of the things we need to do is get that word out to people. And although we know it's already, in fact, has it gone out? Has the Athertonian gone out? And it'll be out soon, okay. So you'll see this in the Athertonian saying, mark this date. But as you know, in the marketing world, you've got to tell people 5 to 7 times the same thing before they hear it. So one time in the Athertonian is not enough. Will the second one not be before September or not? Won't be, will it? No, so this is the only time in the Athertonian. And to add to that, we'll have all the emails and stuff, and we'll send out emails. But we'd also like to do what we did for the other 2 sessions, which is send out a postcard. And the postcard, as you remember from the town survey, everyone, the seniors in the town survey said they love hard copy in US mail, which is the way we think you communicate best with our seniors.
Right. It's a traditional form of communication that our seniors have told us they've come to depend on, and it's a form of communication that they prefer. And Ken has been knocking on doors and hanging out downtown and informally soliciting feedback and input and ideas from folks, and has heard that as much as the Athertonian is beloved, it's beautiful, it's absolutely beautiful, and the content is excellent, our seniors don't look at it as an urgent piece of mail because it looks like a beautiful magazine. So when there's something that has a timing component, it's likely that they might miss reading the information about an event like this.
Well, and it says, when's the next one come out? First week of August, sorry. And the session's the 27th. Our plan on the mailing was Labor Day, have it in your mail after you come back from Labor Day. So the first week in September 10th or something, 7th, you get it, and there it is 2 weeks later.
Right.
So that's the plan.
And the evidence, the initial evidence we have that postcards are very effective for this kind of purpose is we had a number of people who attended the fall prevention workshops specifically tell us that they loved receiving the postcard. I mean, the fact that they mentioned it and they distinguished it as different from the other types of communication that they receive that provide this kind of information. So that is our indicator that we've somewhat proven the theory and would love the opportunity to try it again for this expo on September 27th.
So that's the
Thank you.
answer.
Yeah. And you're asking for $1,800 to $2,000? Which one?
Well, I don't know where the money.
That's what the
I
staff
know that
report
the
says.
mailing cost is X dollars per unit, and there's 2,500 units. There might be some printing cost in addition to that.
Thank you, guys. Okay, we'll bring it back to council for a
Okay, we
little
done?
deliberation here.
Thanks.
Okay,
Sure, thank you.
support that?
Yep.
Want to make a motion?
Can I say
You have,
something?
you want to, Vice
Okay.
Mayor wants to opine.
Okay, so my background is event marketing and creating events. So this mailer sounds like a good idea. I'm gonna say yes to it, but you guys need to work on your copy because what you just described sounds like an amazing, compelling event. Flyer that is in a staff report, to me,
Right here.
it features our dog and it looks like a senior dog party to me. So
That was Ken.
you, just
It
a
looks
birth-
like a
It's like a big
political-
party for Emmy, only seniors involved. So
It looks like a political
I-
ad.
yeah, please, I want, yeah. I'm not allowed. It's
No,
our full,
we-
it's full.
we-
So, but this event sounds amazing. I want it to be successful.
Comment is change
Please.
the flyer.
Please
the
don't
flyer.
use the flyer that was in the staff report because none of the very compelling information you shared is in this in any way. So you
Okay,
could do it.
all right. Okay, I'll bring it back to council. I think that the motion is that we will move to provide up to $2,000 for the senior task force to do a mailing for their September 27th event.
And confirming that there's no other public comments, correct, Mayor Lewis?
Oh, Anthony, no public, thank you, Mona, for, yeah. I'm streamlining. Do I have a second?
Second.
Councilmember Whitmer, second.
Backpacks are.
All in favor? Aye. Unanimously.
Motion to adjourn.
Wait, okay.
Guys, it is 8:39.
All right. Motion to adjourn.